Hi everyone and welcome to NK Real Talks. Today we're going to talk to Azin from AG Law, one of the best lawyers that I know and we've been dealing with for several years. I personally like the fact that she's so responsive because it's tough to get a lawyer these days that is responsive enough. Like you make a call, they get back to you at the end of the day. But Azin is one of the most responsive ones and I would say most knowledgeable one when it comes to especially pre-construction that we're going to get into. But what we're going to talk about today is why do you even need a real estate lawyer in a real estate transaction? So, Azin, why do we need one?
Well, in Ontario, you have to have one. What our job is in Ontario is to make sure that we give you a clear title to your house. When you purchase a property, your realtors are the ones that draft the agreement of purchase and sale. Right. It is our job to later look at that agreement of purchase and sale and make sure everything is correct. Your name is correct on the title. There is nothing else, no liens registered on title or any other issues that will affect you once you actually become the homeowner.
Right.
If you're selling, that's a different story. We also still look at your agreement of purchase and sale. We wait for the purchaser's lawyer to send us the requisition letter. In that letter, we see what mortgages you owe, what liens are registered on your property. We discharge the mortgage, we pay off all your debts, and give you the rest of the money.
So the requisition letter comes from the buyer?
The buyer's side all the time. And then as a seller's lawyer, it's our responsibility to respond to that.
Right.
If we're representing you as a buyer, then we do the title search ourselves and we send the requisition letter to the seller's lawyer on the other side.
Cool. So let's just go step by step because, a normal resale transaction, I would say is pretty, not complicated. It's a straightforward deal if it's not a complicated deal to begin with.
Yes.
But when you're buying a property, let's just start with like the title search. That usually happens 2 weeks prior to closing. Why, first of all, is it 2 weeks before closing and what do they check in there?
So usually we say 2 weeks before closing because during that time, no one else is really going to go and obtain a new mortgage because they've already sold the house, so nothing is going to be registered on title as a new instrument. But what we do is on the land registry system, we search the title of the house. We get a PIN page, which is probably around 2-3 pages, depending on how many times the house has been sold or not. On that, it shows us if there's any easements, if there's any bylaws registered, if there's any mortgages, liens, construction liens, tax liens, or basically anything that will affect the root of the title of the property. It is our job as the buyer's side to tell the seller's lawyer that we want all of those removed from title to be able to get a clear title. Seller's lawyer if we send the requisition letter later than the date that is on the agreement of purchase and sale, a seller's lawyer will basically be like, you have the right to do all this yourself. We're not going to do it. It's your responsibility. You're past the deadline and it's not. The only thing they're not allowed to respond to that is if it's a mortgage or if it's a lien on the property, because those are debts that belong to the seller and they have to pay it for it.
So if it's past that deadline, they can, not do certain things.
Yes. We have this thing that we say, kindly satisfy yourself. It is in a nice way to please go do whatever you want to do yourself.
Right.
We're not going to do it for you.
Interesting. And in terms of the easement?
An easement is something registered on title of the property. It can be from hydro companies, from Bell Canada. These are the minor easements that are always registered. There might be a line of hydro going, Rogers Cable, or some...
And that's for that company to have access to your property to maintain that.
Exactly.
Okay.
But sometimes there are major easements. In the agreement of purchase and sale, it states that if there's any minor easements, you are to assume it. So you cannot come back after purchasing a property and being like, oh, I didn't know there was a Rogers easement. I don't want this. So that's a minor easement and it's considered to be acceptable. There's also an easement for airports. So if you're near the airport, you'll hear the sound of the airplane. So that's an easement and you can't really remove that. But if it's a major easement and we figure it out during our title search time, that's when you would have to obtain litigation lawyers to go and probably cancel the deal. Or sometimes a lot of people are like, if you give me a price abatement, I'm okay to take it.
Got it. And like an example of a major easement would be like right of way probably?
A right of way is depending on the type of property you bought. It might not be a major, but sometimes there is a huge a well or something that you're not well aware of it, and that just shows. So that is a major easement. But a right of way on most of the property descriptions. So if you're buying a semi-detached, it'll say you have a right of way, and you can't really remove that. So that's not considered major. It just depends on the type of the property.
Okay, so that's why first of all you need a lawyer and the resale section, and then once after you check all these, like all the title, whatever easement is on the property, then you guys are responsible in either discharging the mortgage or registering the mortgage,
Exactly.
right? Okay.
So if you're purchasing, we register the mortgage based on the instructions that we received. A hint that I always give to my clients: when you go and obtain your mortgages, they sometimes register the mortgage amount at the rate that you've actually purchased the property, not at the amount that you were appraised for.
Right.
So this later on in the long run, if you ever plan on refinancing or getting a second mortgage, sometimes there's an issue with that because the person that is lending to you will be like, oh, well, you have the whole value of the property registered as a mortgage. So I always tell everyone that if you're getting a mortgage, tell your mortgage broker that you want the registration amount to be the amount that you were actually appraised for.
Interesting. Like, so major banks do that?
Yes.
Really? So like you purchasing a property for $2 million, let's say you get $1 million mortgage, they register for the $2 million?
Yeah, if you obtain like a home line plan, depending on the type of the mortgage, they'll give you the registration amount of $2 million. Not only would you be paying extra for the title insurance because the amount is at $2 million and not at the $1 million you're obtaining, but you're also blocking $2 million on your property, even though you don't actually have to pay the bank $2 million, but it's still registered at that amount.
Interesting. So you guys cash it and you tell the client to revise it.
Yeah.
So that's actually a really good point, because then it becomes a problem when discharging it, or if you want to go probably get a second mortgage, then you got to show all the documents that you don't have that much.
Yeah.
So that is at the discharge statement. And if during the time that you're like closing the deal, there are issues that are arising, people go in, like, there is, let's say, like a leak happens in the house, or there's something that comes as an issue. And I've seen it day in and day out, like sometimes it can get solved because of between the agents, then lawyers also get involved in that.
Yes. A lot of the times we won't be able to do anything if there's nothing mentioned in the agreement of purchase and sale. But we do let the other lawyer know, hey, there's an issue, your client needs to fix it. The agreement of purchase and sale that says that the fridge needs to be in a good working order. Yeah. The fridge is not working. So it is the responsibility of the seller to rectify that at that time. If they don't, we have the option of closing under protest. And what happens is that you then have the right to go and sue the seller. Okay. But you cannot withhold a closing because the fridge door is not working. If you go to court, the judge will be like, you bought a $2 million house, the fridge is worth.
So this is actually a good point that you brought up, because I think everyone should know about this. So what are the issues that you can't really say, I'm not closing a house because of it? Because we run into this problem, like a fridge is a good example, AC is a good example, or something's broken when you go to the house and say, listen, you know what? It was supposed to be in working order, I'm not closing it. Does that warrant you actually not closing?
So there has been case law that it does not, because it's considered minor. So that issue can be resolved or can go into court and be resolved there. But for you to withhold a transaction that's $1 million, $2 million because something small is not working, the courts will not really.
And then when you close under protest, what does that exactly
That
mean?
means that you're closing, you're showing that you're able to close and you'll be closing, but you're closing it with the fact that you know there's an issue and you're letting them know that there is an issue and that you will pursue. So you have 2 years to pursue if you want to pursue anything after.
Okay, so that gives you a leeway to later on go after the
exactly
seller. Okay, so anything else that could go wrong at the closing stage for the resale?
A lot of people for resale. So there's a lot of times there's issues with the property tax bills. Sellers provide us with tax bills. Sometimes a lot of people don't like to pay us to obtain a tax certificate from the city. It ranges from $80 to $120 depending on the city. So everyone signs an undertaking to readjust, and the title insurance will cover if there's ever any issues with property tax bills. But what I always recommend to all my sellers is when you do send us the tax bill to say that you've paid, provide us with proof of payment or call the city. It takes 5 minutes, just get a verbal from them so that it's accurate and you don't get stuck with having to deal with paying afterwards.
Got it. So that's actually a very good point. The undertaking, because I know a lot of people sign these things, they don't understand it. Do you guys withhold some money for a period of time or no?
No.
You just leave it open in case something needs to be adjusted, they got to come back and do it.
Both sellers and buyers sign a document that's called undertaking to readjust. What that means is that they've signed their undertaking that they will pay if there's ever any issues up until the day that they've owned the home for the seller, and then for the buyer, it's from the day that they've purchased the property. if you don't pay, title insurance comes and covers that, and then they go after the seller. So,
Interesting.
and right now with all the frauds going on, title insurance is always recommended.
People selling homes they don't own. Yeah.
So a lot of the mortgage companies require title insurance, but my firm also personally does not close without title insurance.
Okay, perfect. So that is essentially for resale. But another thing that lawyers are, in my opinion, must be used for is at pre-construction stage, which a lot of people tend to oversee because it's not a requirement when you're purchasing a property at the pre-construction stage. So how can a lawyer be involved at the beginning of purchasing, let's say, pre-construction condo first, and second, what are the benefits of having a lawyer right at the get-go instead of the closing?
So when you purchase a pre-construction condo or house or anything, you have a 10-day cooling period. During that 10-day cooling period, you have the option of having a lawyer review the agreement of purchase and sale and try to negotiate some of the terms. So most of the times, us as lawyers, our job is to look at the adjustment section of the agreement of purchase and sale from a builder. And there are development fees, Terry and warranty fees, status certificate fee. There's a bunch of fees that they put on the agreement, and you as the purchaser will be responsible for at the end of the
law and society fee.
Yes. So what we do is I review those for you. I send it to the client and say, hey, these are the fees, but I recommend for you to delete this, delete that. And what they do is they share it with their agent first. The agents have the connection with the builders at first. So they go and approach the sales team and say, hey, my client is okay to sign and finish this contract, but we need certain things removed. Most of the time, they end up agreeing and allowing for that to happen. They cap the development fees, which is very important because you can get an agreement and have to pay around $30,000, $40,000. But if you've capped it, depending on the builder. So if you've capped that, that's solid for you, and you don't have to pay that much at the end of the closing. So your agent can really help you with that. At the end, if the agent cannot get that, then us as the lawyers will send a letter to the other lawyer and say, hey, we're ready to close, but we want these adjustments. And then they send you an amendment to sign. So our job is basically pretty much telling you that based on the agreement, there are certain things you have to pay for, but you should remove them. And that's where we come from.
So this is exactly why you use a lawyer. You use a lawyer at the pre-construction stage, right at the beginning. You involve the lawyer right there and then. So they review the contract, first of all, because the contract is pretty lengthy and you need to know what's in it. There's a bunch of warning clauses. There's a bunch of fees on closing that you're going to be liable. And as lawyers, they can actually outline exactly how much fee you would be paying at the closing stage, 5 years down the road. So that's the first thing. Second thing, they will tell you things that needs to be capped. Us as agents will tell you the same thing. But I would say a lawyer needs to be involved in it right at the get-go so that everything is clear, because the same lawyer will be the one recommended to be the one on the closing as well, because they've already reviewed the contract for you. So they will review that. And if there are any development charges that you need to get capped, you do it right at the get-go. Even at times you've seen park levies that they put in there that you got to pay $4,000, $5,000, $6,000 park levy. We can get it either removed or you put a cap on that, because these things on closing will start to rack up your bill. And, closing time comes, you already have the land transfer tax that you got to pay. And then on top of that, all these fees could easily eat into your pocket.
There's also another thing on closing. So when you purchase from a builder, you're purchasing the price including HST rebates. That HST rebate is up to $24,000. What that is saying is that you are moving into the property. A lot of the times people that purchase under a company or purchase and do not tell the builder that they're moving in, the builder will add that $24,000 to your closing costs at the end. So a lot of people come shocked and surprised. So you need to make sure you notify the builder. If you're buying under a company, you really have no choice because a company cannot really pick their place of residence.
So can you get that back if you're buying under a company?
You would have to apply through the CRA. It takes around 2 to 3 months, but
that's if you live in it or if you rent it out?
If you rent it out.
Okay.
But what we always recommend is if you're living in it, make sure you let them know, you are aware of this, because when it comes to final closing, a lot of people get surprised that they have to come up with an extra $24,000.
That could be a lot of money at that point, especially if you have the levies and fees added on top of that. I would say one of the most important stages that you want to get the lawyer involved. going down the pipeline, on closing, again, you need the lawyer to close the deal for you. But in between, there are other stages that a lawyer should be involved. One of them would be at the occupancy stage,
Yes.
right?
So the occupancy stage is where the builder is ready to give you the house. You can move into the house, but they still have not received the final deed to be able to transfer the title to your name. What happens is during that time, you're basically renting the unit from the builder. And you
Because
really
you don't technically own it, you're not entitled.
Exactly. So, but you also don't have an option of skipping the occupancy period. It is.
That's actually really important. Yeah, if the builder tells you, listen, you're at the occupancy stage, even if you don't go in it, you still have to take occupancy and pay something that's called occupancy fee.
Yeah. So the occupancy fee includes your maintenance fee, property taxes, and the interest that you would have to pay if you obtained a mortgage for the remainder of the purchase price.
Yeah.
So if you bought a house for $500,000 and you have $400,000 left, you would have to pay an interest.
Yeah. So you would have to pay an interest on the unpaid portion of the purchase price.
Purchase price,
Yeah.
exactly.
So that will all tie up into the occupancy fee. So these are the three main components of the occupancy fee, just to wrap it up again. So it's the interest on the unpaid portion of the purchase price. Second is the maintenance fee. And third is the estimated property tax. So, and it's essentially like a rent that you pay till the building gets registered.
So they issue, exactly,
Yeah.
and they give you a final closing date. On the final closing date is when you do your final closing. And that's when you need to have a mortgage ready. If you're buying cash, that's a different story. That's what happens with a pre-construction.
Yeah. So something else that happens in pre-construction is like a lot of people buy a pre-construction condo or house or whatever it is. And at the beginning, if you had a good lawyer or a proper real estate agent, you would ask for something called the assignment right. And you have the right to assign the contract to someone else. So a lot of people in Toronto, because of the way the market has been for the last few years, were able to sell it at a profit. But it is an exit option if your plans change, because these pre-con units tend to have a long period of time for them to get built, so anywhere from 3 to 5 years. So when you're assigning that contract to someone else, again, lawyers need to be involved. And there's a lot of items that a lawyer catches that a lot of people don't know.
The most important thing, first of all, is to have the right to an assignment.
Yeah.
Sometimes in the agreement it says heavy fees, so that's where your agent and the lawyer would have had to decrease the fees or lower them or request for a free assignment. If the builder gives you the right to assignment and you want to sell the property, you cannot list it on MLS, you cannot advertise it. If you do, then you are breaching the contract. So that's where your agent comes in and does the selling through his own network. Once they sell, you as a seller will need a lawyer. The person that is purchasing will need a lawyer. And the builder obviously has their own lawyer. The seller's lawyer would send a request to the builder's lawyer letting them know, hey, we've signed the agreement. Please send us the terms. They would ask for the agreement of purchase and sale and the new buyer. The new buyer will have to have mortgage documents to show that they can actually close this property. And sometimes I'll ask them for certain deposits or certain ID and everything to make sure that this person is actually.
And they usually ask for the actual mortgage approval, I believe.
Yes.
Yeah.
And then the builder's lawyer will draft an agreement. We'll send it back to both parties. They'll sign. And then on the day that you get that assignment agreement signed by the builder is the day when the purchaser will pay your lawyer as the person that's assigning it, your deposits.
Yeah.
And then on final closing is when the rest of the balance will get transferred.
So I mean, like that's again, I believe you can negotiate a lot of those items as well. Original purchasers usually have paid deposit anywhere 10, 15, 20%. So they need to get that back. And if there's any profit, sometimes it's negotiated up front. Sometimes it's left till the closing. Again, that's something to be negotiated. But all this cycle gets done through a lawyer. And again, one of the most important reasons to have a lawyer at that stage as well. But as a lawyer, you've seen a lot of assignments that when people are offered at the beginning, let's say right to lease during occupancy and certain perks at the beginning, it doesn't get transferred to the next person when you're assigning it.
So a lot of times, depending on the builder, they'll say that I will give you a credit for purchasing this property for $10,000, like a $10,000 credit.
On closing.
Exactly, on closing. but then you have assigned the property. So you cannot, it says that you cannot transfer this credit to the new purchaser. So you got to make sure that your lawyer does disclose all this stuff with the person that is buying it, so that at the end of the closing date, when it comes and they're surprised with all these fees, you're not stuck with a...
So that's, again, why it's so crucial to have the lawyer right at the get-go when you're purchasing a pre-construction. At the assignment stage, if you're buying an assignment, so you know, like, if they're advertising certain things like right to lease during occupancy, credits, or certain other things that was offered to the first purchaser, you may not get transferred to the second purchaser, and your lawyer is going to let you know about that. And the other thing also I think to consider, especially with the assignments, is the fact that the HST rebate of the $24,000 is not going to be applicable at that point again.
Yeah, it will not be applicable. Depending on certain lawyers, they might still allow builders, but it's very rare. So that's
you have to pay it up front, but like if you go move into it, you can apply and get it back, or if you rent it out, you can apply and get it back. But it's, again, something to consider at that stage. Anything else for pre-con or assignment we should be worried
think
about?
just for any purchaser, one thing is important. They always get surprised with the land transfer tax.
Yeah, that's a big one.
There's a lot of, like, on Google, if you search, it'll always show you how much it is, so you're not surprised at the end.
Go to a land transfer tax calculator. We got one on our website, nimakadim.com. Check that out. But that's another thing to really consider. And as lawyers, at any given point, let's say at the beginning when you're purchasing the pre-con, even at the assignment, you could give the purchaser a pretty good idea of how much closing costs they should expect.
So when we send them the review, we basically tell them these are the costs that you may face. Keep that in mind. There's going to be a lot of closing costs, so you need to make sure that you can afford this at that time.
Perfect. So again, this whole episode is good for whoever is like first-time home buyer looking to purchase pre-con or an assignment. And if you guys find this useful, be sure to click that subscribe button, share it with the friends. And if there's any comments or questions, leave them below. We got Azin's contact info as well. Feel free to reach out to her, especially with your pre-con and assignment, because I personally am confident with her abilities for those complicated deals. And again, her response time is the best. Azin, thank you for coming.
Thank you for having me.
You're welcome. And thank you guys for watching, and we'll see you next time. Have a great day.